G'day everyone, and welcome to a bit of a deep dive into the principles of justice. So obviously our first key knowledge dot point of both area of study 1 and 2 in unit 3 are our principles of justice. And yeah, they're an interesting one because they permeate every single dot point, as you know from watching the videos. We always at the end look at those principles of justice and how they relate to that content that we've just gone through. So this is a bit of a chance to deep dive into exactly how we want to use them in answers. Very quickly, our quote for today from William A. Ward: "The pessimist complains about the wind, the optimist expects it to change, the realist adjusts the sails." So this is just a bit of a, I suppose, a metaphor around, hey, if you want to get by in life and succeed in life, one of the really important things to do is to roll with the punches. If something gets in your road, if you come up with an obstacle, don't complain about it. Don't just sit there and like, oh, I hope it gets better, or I expect it to get better. Actually adjust, figure out how to overcome it, and then move forward from there. It is worth noting that William Ward is a really old guy who's dead now, who made his money writing inspirational and motivational quotes. He, I don't think, was a sailor, so I don't know if he knows anything about adjusting sails, but it does sort of ring true in terms of year 12 around, hey, you're going to have things thrown your way, you're going to have obstacles, but whether it is something like COVID and that interrupting your year, and you needing to miss time from school, right through to other forms of sickness, you're going to have 18th birthdays, breakups, things like that. It's about your ability to adjust to those and move through, and those who are going to do well in year 12 are going to be the ones who can handle that. So really important to sort of take a step back and think those things through when they happen, rather than just going, oh, woe is me, which can be really easy to do sometimes, and is a little bit, makes you feel better sometimes too. Look, as I said, today we are going to focus on what are the principles of justice, but particularly I'm going to keep coming back to this word how. How should we be using them? As we'll learn as we go through, it's not enough just to know them, and there's actually really no point in knowing them from a definition viewpoint. It's how we're going to use them. So, as I said before, they're the first key knowledge dot point, and it's really this skill here and this skill here that make them so important. And there's been multiple marks on every exam since 2018 asking about one of the principles or all of them, and it's our ability to evaluate whether the criminal justice system can achieve them, and I'll talk more about that as we go on. So look, principles of justice, as we all know: fairness, equality, and access. What are they? What's the whole idea? Well, more or less, what the designers of the study design, or the builders of the study design, are going for is they're saying, hey, if we have a justice system where there is fairness, where there is equality, and where there is access, where these principles exist, then we will achieve justice. Now, there's whole university subjects that will literally spend time trying to understand and define what justice actually means. So we're not going to deep dive into that murky area of what is justice and justice for who, but the whole idea of this study design is that if there is fairness, if there is equality, and if there is access, if they are all there and they are being upheld as well as they possibly can, then the result is that we have justice. What is justice? Well, justice is more or less, I suppose, the right outcomes for all stakeholders involved, particularly if we're looking at criminal, the right people are held accountable for their actions, so ensuring that the people who are held accountable for their actions are the people that have actually done wrong, not those who haven't. For victims, ensuring that people are held accountable for what they did to those victims. For people who are harmed from a civil viewpoint, that they get some form of restitution. Justice is more or less letting people go through the system and get to the point where you have the right outcomes at the end, but also ideally that you don't harm people along the way. So you don't actually cause further trauma or harm to people as they're trying to resolve the dispute. Now, we know this is never perfect and these things aren't upheld fully, and that's the whole idea, is that as we work through this content, we start thinking about both things that are fair and things that aren't, things that are equal and things that aren't, and things that are accessible and things that aren't. Because generally speaking, we want the system to work as well as possible, but it's never going to be perfect. So that's what they're there for. I suppose the first thing we want to talk about is, what does fairness mean? What does equality mean? And what does access mean? And this is where we run into a little bit of trouble, because the study design says, hey, you need to know fairness, equality, and access. So the first thing any good teacher and hopefully any good student will look to is the study design. And then from there, some of the other resources that VCAR produces to actually get an understanding of, well, what is fair, what is equal, and what is access. And we're going to find out really quickly that looking at these things is a little bit problematic. So let's start with the study design. The study design says the principles of justice are fairness. And it says fairness is fair legal processes and parties receive a fair hearing. Now, this should be common in all of your subjects. I don't teach, I've never taught any other subject at Year 12. I've taught some VCE history and some VCE business. And the principles in those subjects, some of the rules in those subjects, they're exactly the same as legals, and that is, you can't do circular definitions. So you can't use the word fair to explain what fairness means. You can't use the word equal to explain what equality means. Yet, in the study design, and you'll see here in the FAQs as well, fairness, are fair legal processes in place? Do parties receive a fair hearing? Are people treated equally for equality? Do people have equal opportunity? We quickly see that they just use circular definitions. Now, I'm going to talk about the examination report in a moment. It literally explicitly says in an examination report from a few years ago, hey, a lot of students use the word fair or fairly to describe fairness. This doesn't show you know what fairness means. You can't use the word fair to describe fairness. So it's really kind of annoying and frustrating that that's all VCAR gives us. So what we more or less need to do for starters is just disregard this and disregard this, because we're going to have to come up with our own definitions. We're going to have to come up with our own meanings for these words, and particularly different synonyms. So similar words we can use in answers to show that we understand what access is without using the word access. And the best place to look for this is the examination reports. So since 2018, there's been 5 questions about the principles of justice. And it's obviously in the examination report we can read, hey, this is what examiners saw in answers, this is what was good, this is what was bad, and we start building a picture of what these words actually mean and how we want to use them. So, there's a bit to work with here. There's a bit on this page, and there's no point really digging down into it fully. It's just all of these, every single one of these is direct excerpts from examination reports. As I said, I just want to start with this one quickly. The Chief Assessor said many students wrote that giving directions was fair or enabled the parties to be treated fairly without expressing what actually fair or fairly meant. Students who scored highly were able to express what fairness was by reference to features such as being treated impartially, without fear or favour, having an opportunity to present your case, or having the opportunity to resolve the dispute in a different way. But it's really, really important that we focus back on this top little section here. Many students couldn't describe what fairness was without saying fairness is fair, or this is fair, without actually showing what it meant. We can extrapolate this over and go, okay, if we want to talk about equality, we can't just say equal. Things are equal, things are equal. We're going to have to work out different words or different ways of describing it. We can't just, the same with access, say this is access, this is access. And that's really important. So what we want to look at is what sort of key words can we pick out. So impartially is really important for fairness. It says clearly in the examination report, hey, something is If something is impartial, it's fair. Presenting your case is fair. That means you're getting an opportunity. It also comes into equality. Some specific things for fairness: having legal representation, presumption of innocence, appeals, being able to change your plea. We'll see here again, impartiality comes up. Impartiality, impartiality, impartiality. This is a central concept of a fair trial. No bias or prejudice, upholding impartiality, key word. And a fair trial requires the decision to be based on the facts presented in court. So it keeps coming back to impartiality with fairness. That's a really, really important one. I'm going to jump to access quickly because it's had more questions than equality, and I'll talk about equality last. To answer something about access, you need to go further than just saying this is access, this is access. The key answer is access to what? Okay, what are you getting access to? Is it info, so building your understanding? Is it the courtroom itself, so without delays? Or is it processes, so being able to go through a certain legal process? Points that could be made in relation to access really clearly are the fact that if you have legal representation, you understand what's going on. You can appeal, that's an access thing. Delays, so delays limit access naturally, so timely resolution of disputes. And it goes into here, you can talk about access for anyone. So the fact that a jury gets to be in a courtroom is something that builds access. So that's a really important thing to know, that the principles of justice apply to everyone, not just parties, not just lawyers, actually just you out in the community. Do you have access to the justice system? Well, you do through the jury system. And it talks about, again, simplifying processes, so again, about understanding. So access isn't just about physically getting into the courtroom. It's really clear from the examination report that it's about understanding what's happening as well. So we're going to build some definitions next. I'm just whipping through this really quickly to show you where these definitions are coming from. Finally, equality. Really difficult. As I said, there's been 5 questions that directly reference one or more principles since 2018. 2 of those questions have been about fairness, 1 about access, 1 has been about, hey, talk about one principle of justice, just says just one principle of justice, and the examination report said fairness and access were the easiest, so more or less equality, not of use. And then the other question was about all of the principles of justice and jury trials. So what we can gather from that is we don't really still have equality fully fleshed out in terms of what it means in terms of this study design. We can only sort of build off what we know from that question about juries, where it talked about, okay, were the parties on equal footing? Using the word equal, I don't like. You'll find that maybe the only really, or the best equivalent to this is just saying were the parties on the same footing. It says that, using a random jury and having impartial judges upholds equality. I guess that's from case to case. Probably the big one that it talked about with equality that I haven't included here is it said that a lot of students on that jury's question said, hey, you get a jury for indictable offences but not summary. That's not equal. And it said that's not actually a point, because you're comparing 2 different things. Someone in charge with an indictable offence and a summary offence are really different participants in the justice system who don't really need equality because their circumstances are different. So it's very important. We know from that equality is for people who are in, things are the same for people who are more or less in like or similar situations. So using some of this info from the examination report, equality being more difficult, as I said, we can build a bit more of a better definition of what fairness means, what equality means, and what access means. So this is what I've done here. These might be worth jotting down. So we know that central to fairness is impartiality. So maybe a definition of fairness in terms of this study design could be, fairness is being treated impartially. We'll skip back. Being treated impartially and without bias, and ensuring that the right decision is made based on facts and evidence. And that's kind of 2 sides of the same coin, because generally speaking, if a decision is made on facts and evidence, it's not made on bias or prejudice. It's not made on information that is not presented in court. It's not made on information that perhaps makes someone biased or prejudiced towards a witness or a party involved. There's been a really recent case, actually, just very, very quickly, where a jury's just been discharged because it related to a sexual assault that occurred in a caravan. The sexual assault is alleged to have occurred at, I think, approximately 4:30 in the morning. And one of the witnesses talked about the level of light in the caravan at the time. What this juror did was, this juror went home, they had access to a caravan, and they ran their own experiment on how well they could see in the caravan at 4:30 in the morning. Because they were like, this will mean I can work out whether that witness is telling the truth or not. Now, this immediately, based on information that isn't presented in the courtroom, that is completely different to the circumstances of the case, makes them have prejudice towards that witness. Because if the information that they receive from their little experiment is different, they're going to automatically discount things that that witness says when they shouldn't. So the result is that trial is no longer going to be fair, that jury is discharged. So we want decisions to be made based on the information and facts presented in the courtroom, not on any bias or prejudice or outside info. So that's what fairness is. Equality, the most difficult one, we've gone with to be treated the same, and particularly it's the same to other parties in the dispute. So you have the same opportunity to present information and evidence to the court, but also the same as similar users of the justice system. So people who are charged with indictable offences are treated equally, because we want, we can't have favouritism, we want people to be treated the same and treated equally, and this is one of our principles. And again, it all comes back to ensuring the right decision is made. Finally, access. As we alluded on in the last slide, access really comes in two packages. So there's two definitions here. Access is understanding legal processes and procedures, understanding your rights, understanding how things are proceeding, what you need to do, what you don't have to do. Things like you don't have to prove you are innocent if you're accused of a criminal offence. You have access if you understand these things. So it doesn't just have to be physically getting in the door, it's also knowing what's going on is really important. But access is, in a more simple form, just getting in the door. Getting your dispute resolved is access, and that means resolving it without delay and having a range of methods and institutions. This is really important in civil law, when you have access to bodies like CAV, VCAT, or the courts, but also criminal and civil as well with appeals. You have a range of institutions within the court system to resolve your dispute, and you have access to that. So access is understanding, but also then getting in the door. So these are definitions of what fairness, equality, and access mean without actually using the words fair, equal, or accessible. Okay? Very important, you might think. But our skill, as we spoke about, is evaluate the ability of the criminal justice system to achieve these principles of justice. Now, we go over this in every video with our table at the end, but we know to evaluate something is to look at more or less the positives and the negatives, and from that come to effectively what we call, I've lost my pen there, what we call an argument or a conclusion. So how fair is the system, how equal is the system, how accessible is the system? As I said, definitions of them. We go to the examination report again, and we look straight back to, we can look at 2018 in a moment, but if we look at 2020, there's this, really lovely opening line that says, higher scoring responses demonstrated a well-developed understanding of the three principles. So good, we need to know them and understand them. Great, we've got definitions. But long introductory descriptions of the principles were unnecessary. there is no need to define the principles within your answer. So you don't actually need to use these definitions in an answer. You don't need to sit there and go, fairness is this, to then explain something being fair. You just need to show that you understand it in your answer. It should be clear from the answer that the student understands the principles, but you don't need to define them. Again, here, this one was about access. The differentiating factor was the explanation of how the rights upheld access. It was not necessary for students to give a description of the right itself before providing the explanation. Okay, again, it's not about defining things, and this is in this case rights of the victim. It's not about definitions. It's about how. It's about showing, and it says here, how they were or were not achieved. It's about showing how something is fair, how something is equal, how something is accessible, without actually spending time defining what those words mean. So how do we do that? So here's the questions that have been on the last 4 exams. I've just included the A here to show you identify 2 rights of victims, and question B, explain how these rights uphold access. So how is access achieved? Kylie is a professional sportsman. She's commenced a civil proceeding. Explain one way in which the judge's use of case management powers in this dispute could achieve the principle of justice. Principle of fairness. So, again, how? How is it fair is our key word. Discuss one of the principles of justice in Mr. DeOrder's criminal case. So, if we went with fair, how fair was it? It's all about how. Do jury trials achieve the principles of justice? So, again, do they achieve it? So how fair are they? How equal? And how accessible? So, you see again, and finally discuss one factor that could affect the ability of the criminal justice system to achieve fairness. We are just centrally focusing on how something is fair, not defining it, not providing a description of what fairness is, or equality or access, but actually saying how is case management powers, or how are case management powers fair? How are these rights upholding access, providing access? How fair was the order's case? How equal are juries? So it's all about how. So, how do we do that? This is where I think you can get the most bang for your buck in terms of smashing out some really high scoring responses. The first thing to do, and this is, look, more or less this is just stolen from Teal. Okay, we know Teal. We all probably hate Teal. Maybe you don't do Teal at your school. Teal is the idea of a perfect paragraph, which English teachers hate now. A good paragraph has a topic sentence, it then explains something, it provides evidence, and it links back. Effectively, we want to do the same thing when we're talking about the principles of justice. Okay, we want to start by identifying something, we then want to explain it, and then we want to expand on it. Okay, so IEE, some people call it statement, so they call it C. They say statement, explanation, evidence, or expansion. It doesn't really matter how you describe this or what you call it. It's more or less important that you do it. So how do we do what the assessors want? Not just do definitions. This is, I think, the system that works. You pick a specific feature of the content of the question. So say if the question is about juries and fairness, we don't jump straight into talking about fairness. We go, okay, what's something about juries that are fair? Let's go a specific feature of juries, not just juries are fair. We're going to go, hey, juries are randomly selected. That's a really specific thing about juries that we know. So it shows some knowledge. Juries are randomly selected. Let's explain that feature. We're not getting into the POJs yet. Okay, you might want to start prepping and thinking about using some words like impartiality, etc. But we're just explaining what it means that juries are randomly selected. Now, this is a pretty poor description from me, but it's showing the evolutionary process of this answer. Juries are randomly selected. This means that a pool of members of the community is assembled and then a jury is selected from this pool. This means that the jury, being randomly selected, has no connection to the case, etc., etc., etc. So they come in, they are randomly selected, they don't know any of the details, they have no connection to the case. It's only after we've explained that feature in detail, we've shown we understand this feature of juries, that we then connect it to the principles of justice. And the best way to do this is to start with this sentence: this is fair because. Or if you're doing access and you're saying juries are made up of members of the community. Members of the community are randomly selected to be on a jury. This is, or this promotes access because. So this is fair because in this case, this is fair because it ensures jurors make a decision based on the evidence before them, not on any bias or prejudice. Okay? So I've used key catchwords like bias or prejudice. I could say they make a decision on the evidence before them, which is therefore they're making a decision impartially, ensuring a fair outcome. So again, identify, explain, expand. Okay, we don't bring the principles in until we get to that last section of this. Here's some sample answers off examination reports that I think show this really well. This is what examiners are putting forward and saying, hey, this is what you should be looking to do. This one here, really, really good from 2018. One way in which a judge's use of case management powers achieves fairness is to give directions about discovery. So it picks a specific thing. Hey, judges' case management powers, they can give directions about discovery. And it then proceeds to explain what that means. Okay? Doesn't get fixated on the principle of justice yet, doesn't jump to fairness. It explains what directions about discovery means. A judge, so this is the identify, this is the explain. A judge has the power to order parties to disclose certain documents or limit the number of documents to be discovered by the parties. Okay? So it explains what it means by the opening statement. It's only now that we expand into the principle. By doing this, Kylie and her former agent will not be caught by surprise by about the documents the other side might produce. It puts both parties on a level playing field and does not create trial by ambush. You could then put in that it means the right decision is going to be made, or it means the decision is going to be made based on the evidence, not other factors like bias or prejudice, to bring in some of those keywords. But it's effectively saying, hey, here's this feature, this is what it means, and then this is how it shows fairness, because it means the right decision is being made. So fairness doesn't get brought in until that last statement, that expansion. Okay, so really, really important to try and follow this structure, because it's literally what they're putting in the examination report and saying, hey, these are good answers. Our next one, one factor that could affect the ability of the criminal justice system to achieve fairness is costs. And it talks a little bit about, hey, it explains what this means. Again, identifies costs, explains them. There are significant costs associated with an accused defending a criminal charge, particularly legal representation. And then if an accused cannot afford legal representation, then they may not be able to understand the legal terminologies. So it's expanding here, meaning they may not have a reasonable opportunity to present their case, reducing fairness. Again, chance to throw in buzzwords like impartiality. The decision might be made on bias or prejudice because they couldn't present their case properly, not the evidence, but it's all coming back to this idea of the right decision is being made. But again, fairness doesn't start getting talked about here until the end. It starts by saying, hey, here's costs being an issue. Costs are an issue, or a factor that drives costs is the need for legal representation, and then it talks about how that impacts fairness. So again, identify, explain, expand. What you're looking to do in those expansion statements is really answer these questions. This is fair because, and then putting in how is impartiality ensured. How is the right outcome being reached because of this process that you just explained? Equality, okay, really important. This is equal because, well, what process is the same, or who is being treated the same? That's really important that you talk about who is being treated the same, not just saying, hey, this is the same. Well, the same for who? What's the same? What process is the same? Is it the same in every case? Is it the same in every indictable offence? And finally, accessible. This is accessible because of this isn't accessible because, so what further understanding is the party gaining? Hey, if you're talking about a lawyer and then a lawyer does this, this is accessible because by having a lawyer, the parties have a better understanding of or the accused person has a better understanding of their rights, thus having access to the legal system. Or if you're going down that getting in the courtroom approach, how are delays reduced or efficiency increased? So what are you sort of trying to answer in that last statement to show something is fair, to show something is equal, to show something is accessible? Obviously, just this skill as well, we do need to apply it to actual or hypothetical scenarios. Again, I just want to throw up this question from 2019. The hold to order case caused a lot of consternation with legal studies teachers about its difficulties. But the last question I thought was actually pretty good and pretty straightforward. Discuss one principle of justice in relation to the orders case. And it gave you a big case study to look at. And again, the process is the same. Identify, explain, expand. So you'll see here, look, you don't need to do this, as we know. It is the ability of you to understand your legal rights. Don't need to waste your time doing this. So it starts by identifying a specific feature of the case. This is where it slightly changes for a case study, but it says, hey, here's something from the case. In this case, yada, yada, yada. It takes a while to get to its point. It talks about him being low socioeconomic status, etc. But it says in this case, he was able to qualify for legal aid and receive representation from VLA. So it identifies that. It then explains what that means. This therefore increases the order's ability to participate in the trial and understand his legal rights compared to if he did not have the aid. Okay? And it talks about the fact that he's gets legal aid because of his socioeconomic status. So it explains a little bit about what that means as well. But it says, hey, he has more understanding as a result of having this legal aid than he would if he didn't. So sort of explanation, and then just drives home that expansion. Therefore, his access is enhanced in this aspect. So even if you're using a case study, you're effectively using the same process. Identify a feature of the case study, explain what that means, explain what getting a legal aid lawyer is, and then drive that expansion home. Hey, this means his understanding is built, which therefore means he has access. Okay? Ultimately, at a minimum, you are going to get, I would say, 5 to 6 marks worth of questions. It's been up to 10 in the past on the principles of justice on your exam. On an 80-mark exam, that's a pretty big chunk. It's a pretty big chunk to want to be doing well. And again, the key is how we expected to use them. And the differentiation there is don't explain them, okay? Don't know what they are in great detail necessarily to put really strong descriptions there. It's a waste of time. Your examiner's going to skim read them. It's using those expansion statements to link them to the content. Identify a bit of content, explain it, and then really link in things like impartiality, understanding, who is being treated the same, what delays have been reduced to illustrate that principle. If you can do that, you will score really well. Any feedback, as always, welcome in the comments, shoot us a DM, comment on Facebook, etc. But hopefully this helps you nail your any upcoming SACs or your exam if you're watching this later in the year.